providing legislations to criminalize paternity fraud in Nigeria, should we not be looking at looking at the root cause of paternity fraud, which happens to be some customary laws or customary laws in place? Let us look at the root cause of paternity fraud and tackle such root cause. So my question now presently is, what is the root cause of paternity fraud, and how can we prevent this menace rather than waiting for the crime to be committed and punishing the crime? Because like this.
Thank you. Okay, we will look for the root now. Don't worry. Please come. We have a senior police officer who will investigate it and tell us where the root is. Please give the mic to the man. No, our problem is looking for the root of the problem. We'll find the root.
Thank you, Mr. Chairman.
Yes.
I'm Dr. DJ Usman, Provost, Kano State Anti-Corruption Institute from the Kano branch. I just want to add and emphasize a point. Under Islamic law, there is an opening that you can question the paternity of your child, and that must be done timeously. You can deny the paternity of your child by what we call mutual implication, in the sense that you can swear to fore oath, inviting the wrath of God on you if the child is indeed your own. And then the woman will be asked to also subscribe to the fore oath, swearing that the child is yours, and if she's lying, may the curse of God be upon her. If that procedure is taken, the child belongs to the woman. The father is not the father of the child. So in that respect, he can inherit the mother, but he cannot inherit the father.
Thank you. We have come to the end of that part. Can I get perspectives? I'm sure those on the front row heard all those reactions. Like what my brother was saying, in my village, we don't have problem with DNA. They will bring the native deity and tell you. Nobody will tell you to say the truth. Am I wrong? In my village, we don't go for the DNA. The deity will be there, say whether it's my child. That matter is God. Please, let's take Professor Wasonye first. And then, just those on the first row, let's get their perspective.
Let's start with the deities in your village. If they are so effective, we might recruit them to help us fight corruption. Maybe that will help. But on a serious note, I think that we need to look at the cultural foundation for what we're discussing, and it's very important. I'm not persuaded that legislation will change anything. I'm not persuaded. And I think that let's bear in mind that there are cultures in which, in this country, where a man receives a very important visitor, there are cultures. They give their wives, they don't mind cohabitation with their wife for the period. Okay? Now, if the visitor goes and the woman gets a baby, can the man start doing DNA later on to challenge and all that? So, Professor Yewo has left. He told me about some cultural in his part of the country where a man is unable to father a child. The elders will agree and identify a family member that can have sexual relations with the wife, and she will not know. They will make sure that she's drunk or asleep, whatever, and on somebody who looks like the husband within the family. And she was giving me an example now. If the woman does not give consent, is that not an offense? Rape in another angle, yet the culture permits it. So I think that what we're looking at, it calls for deeper research to see what cultural practices encourage this sort of thing. And as some of the panelists have actually said, we need to diminish the pressure about having children within wedlock, make adoption, and not criminalize or stigmatize surrogacy. These are all very important factors. Last point, there are situations in which when you talk about paternity fraud, fraud requires mental element and the actual action. There are many situations in which the woman is in fact ignorant herself of what has happened. Okay? So it is not every situation in which this is orchestrated. So we need to break it down into chunks and not get carried away by the few sensational cases that have hit the media. Thank you.
Thank you. Please give to Chief Ogala. But before we get to Chief Ogala, let me stand and say what I'm going to say. Women, particularly in this audience, I want to give it to you as an assignment. Go and, if you've not done that, go and buy an LLM or PhD form and research on this point. Because that's the only way we can cure these things. I want us to publish research works. 2-3 women come together, do academic papers, research academic papers, globally acceptable papers on this point. We are not just talking. Because there are series, you could see the perspective Prof has gone to, and I wish that Professor Weo will come also and give his perspective. Let's hear Chief Ogala instead.
Thank you very much,
Yes.
Prof. Well, Professor Wasonye really covered the field. And for me, it's even the concept of using the word fraud. And there seems to also be too much concentration on the children. And that's why I heard people talk about Child Rights Act. Like Prof have said, there are instances where you are even ignorant, where the woman is ignorant. Then beyond all of that, who even says that even me, a 60-year-old man, could not be said today not to even be the child of the man who I think my father is? So when we over-concentrate on the Child Rights Act as if it only applies to children. This could also go as far as even Professor Owasonye himself, and even me. So I think, like you've suggested, there needs to be a lot more research on this subject. Popo talked about his cultural practice, where you will cross a certain whatever it is as you come into the house. And I don't know if those things still work, because if they work in your village, please, I think for anti-corruption we could have it in Abuja, that once you cross into Abuja and you put that thing and you get corrupt, you will die also in office. So I think, like you have suggested, there needs to be a lot of research. We need to take it even far beyond children. The DNA, I mean, for those who may know, there's a program which I would recommend to all of us to watch on TV. It is actually called Paternity Courts, George Lauren Lake. It is very educative. You will see grandfathers being brought and they are even doubting the paternity of 2 generations back, even of persons who have already died, both mother and father. And they are now going to even use relatives. So it is a very wide subject, and I think the discussion should continue.
Thank you, sir.
Even within Spidel, outside this
there
conference.
There are some of these television programs we will not copy in Africa. Chief Gazam, are you saying anything? Okay, please take the mic before we get to the police.
Yes, Mr. Chairman,
yes, sir.
I patiently created time since morning when I came in to listen to Basil, who has consulted for me over 20 years on digital issues, and of course to listen on the data protection and what have you. But you alluded to one point, and it has come to be true, that paternity fraud at the end of the day will become the most sensational topic at this conference. And it is so. I became so interested, and I want to make a twofold intervention. One is a comment shortly, a short one, and then secondly, to ask a question to the speakers, particularly Professor Usman Martins, and then Dr. Ebiala. Now, my comment is this. I subscribe to the opinion that it should not be criminalized. Why? The answers are simple. The child is innocent. Because if you want to criminalize whether the mother or the father, as the case may be, in most cases the mother, who takes care of the child? Because the child is entitled to parenthood and to be taken care by the parents. In fact, even if you want to punish the mother, how do you punish her? What kind of punishment? Jail term? The little money she has and she's looking for more to take care of the child, you want to collect it when she needs more from the system, from the society? So I believe that the crime should not be penalized. You should not criminalize it. Leave it the way it is. Let us improve on it. Now, on what has been said, there is a school of thought, I think, there appears to be a synergy, a link between the Islamic position, and I read Hulson as well. I did little of family law in Islam. Then what he said, there is a link between the position in criminal law and what I purpose said, even in civil law, in the sense that he said earlier that if you do not do DNA within a year or two, forget about it. Nobody will listen to you because equity helps who? The vigilant and not the indolent. And equity wants you to act in good time. Delay defeats equity and you become guilty of laches and acquiescence. Keep that aside. I want us to see if there is, that's the question now, whether you can strike a balance between that position and then between that position of saying that the father does not have the right to raise the issue, and then considering the issue of fraud. If someone has been deceived as a result of fraud and then accords paternity to a child and then stays with the child for donkey years, right? Not because of the person's consent, because the person was deceived, can that person have a right? And someone asked a question, I think it was Dr. Biala, that what about if you have the parent who now knows that that child belongs to him? Can you stop that parent from coming to take his child if actually that is his child, no matter the number of years in between? I think these are the rhetorical questions that we have, and we need answers from you, the experts.
Well,
thank you.
Well, the answer will come. Let's hear from the police. We are coming to you, sir. Two of you are coming.
I will just say something that is the follow-up to what Gazama, the Leonard Silk, has just finished. Paternal fraud is something that does not have a definite definition. All of us here can define it several ways. It depends on how you see it. It depends on how you view it. It depends on how you feel about it. It depends on what you know about it. We have several cases where paternal fraud takes place. If you have somebody who wants to give birth in the maternity ward and suddenly somebody comes, the person might be a nurse, takes off the baby and brings a dead one to her. It's a serious fraud. And in that case, you may not even be able to do something. If you want to investigate, it's going to take, unless you are a forensic investigator. Even as a forensic investigator, it will take you time. We have several of such cases. But I will be very brief. My opinion about fraud, whether paternal or maternal, is that in the court, if you have a matter, it could be civil, and both parties decided to get into a memorandum of understanding and submit same to the judge. The judge adopts it as a consent judgment. So my opinion is that if we have cases where both parties, both the mother and the father, adopting or whatever, agree to take care of that child, then we should not call it fraud. So we should encourage parents to ensure that they don't go or take extra length to, do things like stealing of children and some other things. So in my own opinion, where both parties agree, it's the fraud is mitigated and they can go ahead to take care of that baby.
Thank you.
Thank you very much.
Thank you. Please, please, sir. So if a child grows up and suddenly hears from another child that these are not your parents, and he finds out and sends a petition to your office, will that petition be investigated?
Yes, definitely. It will be investigated. If the biological parents, in fact, I had one where, I don't want to personalize it, where a woman gave birth to a baby in the maternity ward. In fact, she left the baby because both her parents and herself were very poor. After giving birth to the baby, she called the mother, and the mother said, I cannot afford to take care of this baby. So what did she do? She left the baby with the nurse. Lucky enough, the nurse was barren. So she took this baby, and at the age of 6, this woman came. She just appeared from nowhere. In fact, she came with a lawyer. And I'm not taking it too personal. She's a military woman. And then she said she wants the baby. And it provoked a lot of thought. That why didn't you manage, even at the time you were poor, and then take care of this baby, to make sure that the baby grows with you. The baby was a boy, and the boy became very emotional because he was to be handed over to the biological mother. He became very emotional. It was very traumatic.
Thank you, sir. We've seen your perspective. We've seen that.
So what I'm saying is that, like consent judgment, if there was consent judgment, you would not hear the problem. There are hundreds of problems like that going on. Nobody knows. I agree.
We are looking at a conflict situation. Let's hear Chief Bolaji Ayorinde, so that Prof will catch his breath. We have been targeting you, Prof. We expect to hear something from you.
If Prof wants to speak first, can I? Thank you. I think we have a cultural problem. In this hall, majority of the people on this side are men. Majority of the people sitting in front are men. Then we now all come together and start talking about how to criminalize a woman's conduct. I think there's something wrong. What is paternity fraud?
We only talk,
A man lies to his wife every day, every minute. We are not trying to design a crime for that. Then, my chairman, I agree with what you said earlier about the gentleman in skirt researching, coming up, but it is not them. It is Spidel. It is Spidel.
If the president
should have a
gives us the job, we'll do
mission
it.
statement with regards to what we are discussing. It's a cultural thing. The men are powerful. So, we're talking about fraud. Really and truly, it's neither here or there. If it happens in a family, they come together, they sort it out. I don't even want to go there mentally because it's a cultural thing. We need to empower, Spidel, empower the women, look at the girl child education, make her at par. That woman you want to accuse of fraud, if she was the breadwinner, you will keep quiet. Thank you.
All right. Thank you, Chief. Let's hear Prof. Chief Ayorinde, I can tell you that once we get, we don't have any objection from our leader, President. In Spidel, we will set up a research and publish a research in the next 6 months or 1 year on this point.
Thank you very much, Mr. Chairman. I've listened attentively to both, sides of the topics, but I think the hot one is the one I will look at. That's the paternity fraud issue, and I will start from the premise of the Constitution, since that is my area of comfort. The Constitution in Section 42 believes that a child should not be discriminated against on the basis of the circumstances of his birth. Taking a cue from that, the Child Rights Act also focuses on the best interest of the child. And the best interest of the child is that it should be protected from the errors, mistakes, and whatever of the parents. And also, if you look at the Evidence Act focuses on the principle of parenting, because it is not every father that is a parent. Some fathers are just donors. They can donate, they cannot sustain. So basically, in that light, you see that the convergence of our laws tends to support the position that if a child is made in a wedlock, then of course the parentage belongs to those in the wedlock, the father and the mother. Now, the problem that we are having is actually against the legal framework we have. So which means that we have some cultural problems. And one of the solutions have been proffered by a lady who spoke on adoption. Adoption, if adoption is acceptable as an alternative to natural procreation, I think most of the problems will be solved. But even when a man wants to adopt, he has to think about the larger family that he belongs to. So you find out that depending on the exposure of each family, there are so many families through, interaction and all that are able to accommodate, adoption. But when you move out from the urban areas and you go to the rural areas, even culturally, there are ways of dealing with it. I was sharing with Professor Owasoye some cultural practices in my neck of the wood, which is when a child is growing up and he cannot father a child, the elders will sit together and determine how he's going to marry. And most people, they will be cautioned not to marry too far. So that if he marries within an area where these cultural practices are known, then with consent, he can become a father, a parent without fathering a child. And basically that is consensual. That would not be a problem. And the person who tried to make a distinction between paternity fraud and paternity mistake. Of course, baby factory is a no-no. In all the discussion we are talking about, there are other provisions of the criminal, that will catch such people. So the first question we need to ask in solving this problem, which we normally ask, which is a school of thought we share in Faculty of Law, University of Lagos, what would be the criminalization policy of criminalizing paternity fraud. And in looking at the criminalization policy, what will be the other laws that you need to put in place that will deal with it? Because if you criminalize, that will also fly in the face of the Constitution that is trying to focus on criminalizing an act that is gender specific. So which means you are focusing on the gender because they are the weaker and what has been said. So what happens, like the lady said, when the man commits what looks like paternity fraud on his spouse by having children outside wedlock, and when he's 80 and about to die, he tells the woman, before I die, you need to know, I have 3 children outside the wedlock. And in most cases, when there is a disequilibrium through criminalization, there will be disequilibrium in the family, and in fact, the incidence of it will be on the child who has lost a parent who is not his biological father. So I think the problem is more complex, and it has to do with even our cultural practices, and I don't think criminalization should be the first port of call. We should think through other laws, adoption, other alternative. As you are talking about DNA, there's also other methods of procuring a child through vitros, all those things. So I don't think it's a single line problem. It's a problem. We also need to educate people to accept adoption, and of course, where a person cannot procreate, it may not be his fault. It could just be biological. Personally, I have people in my family that we've seen they've adopted. I have people who are married and they know that the child is not their own, and they are fathering the child to adulthood. And I have people who, it's not that they can't have children, but because of some biological something in them, they shouldn't have gotten married, and they are coming together will never produce a child. And they know that, and they chose to stay together and adopt children. Even though if they go their separate way, they could have said, okay, you go and have it with somebody whose gene is compatible with you and all that. But they stay together, they have adopted children, and in fact, as the children grow older, they look like them. So I think the problem, if you look at it from the constitutional legal program and all that framework, it's a problem that looking at criminalization will not be the only thing that we have.
Thank you, thank you, thank you. We now come to the end of this joint session. Thank you, all the panelists. Thank you, my co-chair. And thank you, ad hoc panelists that came to our rescue. The discussion continues, but I can assure you that from Spidel, by the next conference, we should be publishing a research work on this point. Thank you and thank you. Okay. Now, the last thing we will do before we close this session is the session where we want to launch a particular app that will be driven by our president. Please. Mr. President will lead out in this. That is the showcase session. Please don't go away. This is the highest point of the conference. And I'll hand over to the moderators to drive this. Chief Folake Sholanke is here, but it will be driven by our overall boss, the president of the bar. Thank you. Can we quickly take the photograph and leave?
I want to invite Nta Ebiten, the coordinator of this session. I want to invite Kehinde Adeyemi, coordinator of this session. This session is to talk about MBA's work on human rights issues. So there are no paper presentations, but to highlight what the issues are. And I advise dear Leonard colleagues, that we stay behind as a human rights abuse online reporting platform will be introduced to the members of this profession. And it is for professional and social use. Kindly stay behind and take. And we advise, because the presentation will be made on the screen, we advise those at the back to move forward. It's just a 45 minutes presentation, please. Just a 45 minutes presentation. Please, can you move forward? Nta, over to you.
Good evening. We'll be standing on existing protocols because time is fast spent, so we're just going to get into it. The topic of this session is capacity building and enhancement of practice skills on public interest lawyering, a continuing professional development perspective. I'd like to quickly invite the chairman and moderator of this session, who is the vice chairman of MBA Spidel, Mr. Ihedi Ehegila. Please, can he come up? Please, a round of applause. There are two main speakers for this session. The first speaker is Mr. Tobina Erojikwe, who is the chairman, governing board of MBA ICLE. Please, can we have Mr. Tobina Erojikwe? The second speaker will be Mr. Aderemi Oguntoye, member MBA Public Interest Litigation Committee. I'll just hand over to Kende to introduce our discussants.
Welcome, sir. Ladies and gentlemen, may I invite Mr. Jude Ehiedu. Mr. Jude Ehiedu, a human rights law advocate and partner, Legal Fit Partners, Lagos. Mr. Jude. A round of applause for Mr. Jude, please. And also, Professor Mrs. Bangboshe, SAN, the Dean, Faculty of Law, University of Ibadan, and the chairman of the NBA Women Forum, will be joining this session virtually. A round of applause for the Leonard Silk, please. Please connect with the Leonard seat now, please, ICT. We also have Mr. Olukunle Edun, the National Welfare Secretary of the NBA and a public interest lawyer on this session. A round of applause for Mr. Olukunle Edun. Also, may I invite the representative of the chairman of the NBA Lawyers Forum, Young Lawyers Forum, Mr. Toby Adebowale Esquire. He would be represented by the YLF chairman of Ibadan branch. Also, we have a Leonard Silk, the executive director of LIDAP, who will be joining us on this session through the virtual session, actually. Please put your hands together for Mr. Chino Obiagu, SAN. We would also be having on this session the secretary of the NBA Human Rights Committee, Mr. Bernard Oniga. Mr. Bernard Oniga. A round of applause for Mr. Bernard Oniga. And finally, we have the D. Calterium Limited, the developers of the Sorosoke app, a human rights abuse online reporting platform. This is one of the highlights of this session, where this application will be launched by our president. Ladies and gentlemen, please put your hands together for Mrs. Michelle Omogun Anekwe as she comes to the stage. A round of applause for Mrs. Mitchell.
The President of the Nigerian Bar Association, learned senior advocates here present, I respectfully recognize the presence of Chief Mrs. Folake Solanke, who is present with us this evening. This is actually the capping of the whole exercise we've been having since the beginning of this conference. And what we are doing is setting a framework for public interest lawyering in Nigeria. Now, lawyering in public interest would require a lot of sacrifices. And I believe, for one, that first you must take law practice as a business and as a calling that will put food on your table before you start chasing after cases that you do just in the interest of the public. So we are looking at setting the agenda, capacity building for public interest lawyering, and then looking at the activities of the just constituted Public Interest Litigation Committee of the NBA. I have been informed by the chairman of Spidel, my boss, that we have just 30 minutes to wrap this up. And I would implore everybody to keep strictly with time. The major speakers will have 7 minutes each to speak to their papers. We do not want somebody reading from page to us. And thereafter, we have 3 minutes for each of the discussants to throw light on what we are doing here. So I call on Mr. Tubina Erojikwe to give us his position.
Good evening, Mr. President, Mama, delegates. I stand on existing protocol. I was going to deliver a 30-minute paper, but we have 7 minutes. So I'm going to compress it as much as possible. I was asked to talk on capacity building and enhancement of practice skills on public interest lawyering, a continuing professional development perspective. I understand that we are all hungry and ready to go, but it will be good at least to keep quiet and hear what we have to say. So the topic is actually an interesting one because it raises 2 fundamental issues around the situation of our country, Nigeria. One is on capacity. That is the ability to do the things that we hold ourselves out able to do. And this is particularly significant for lawyers because, of course, we have a duty of care to our clients, and indeed, we must carry out our activities and our work at the highest level with the highest level of professionalism. So it's a problem that we have across the board everywhere in Nigeria, and so it is something that we must talk about even as lawyers all the time. And the second one is the public interest. And I think it's the failing and the failure of society that we no longer ask about what is right and what is wrong. And there is no better profession or no better placed profession to ask those questions than the legal profession in Nigeria. So we at the Institute of Continuing Legal Education are excited about the opportunity to actually work with Spidel in advancing and developing curricula that would actually encourage and deepen the body of public interest lawyering. Now, one of the interesting things about public interest lawyering is that if you try to carry out a research on public interest lawyering, you'll find that there is no consensus on what it means. So it actually differs from jurisdiction to jurisdiction. But you find that behind it is the social issues that each environment and each country has. So for instance, the issues you have in America or China or in Brazil are different from the ones that you have in Nigeria. But at least there is some sort of consensus about what our issues in Nigeria are. And because we are gradually moving to what is called a failed state, I think that it is very, very critical and important that we pay more attention as lawyers to public interest lawyering. And indeed, I posit that every lawyer in Nigeria is a public interest lawyer, because every day we engage with authorities and organizations that exhibit crass impunity and disrespect for the rights of people. And it's indeed that element that we think that Spidel and all Nigerian lawyers should rise up to. And so from a continuing development perspective, how does one approach the resolution of these issues and actually train and equip lawyers generally to be more active in this area of endeavor? I mean, many scholars have said that in defining public interest, some have tried to define it using the representation. So who do you represent? Others have tried to define it using costs. But because public interest differs from one person to the other, sometimes it is based on the political leaning. But at the end of the day, in a country like Nigeria, where the issues are almost obvious, it's important that at least we challenge them. And so how do we intend to carry out the trainings that we talk about? We look at them from two perspectives. One is philosophical and jurisprudential. That is, how do we create a consciousness amongst our people through training? How do we create a consciousness amongst lawyers through training around those substantive elements of law that we were taught in school that were fundamental indeed to our becoming lawyers, that might not be as profitable as some of the practices that we do or we carry out, but are indeed fundamental to lawyering itself. And so, taught courses like constitutional law, jurisprudence, administrative law, based around contemporary issues that bother on Nigeria, are things that the continuing professional development committees of the various sections, and indeed the ICLE, intend to focus on going forward. Then the second bit of it is actually the skills that are required. So how do you go about the issues? I mean, I think today in Nigeria, when you talk about public interest lawyering, the focus is actually on public interest litigation and going to court all the time. And we've had many successes. I mean, very successful public interest litigation lawyers like Ganifa Wemi, Dr. Abakaba, and the rest of them. But we are looking at a situation where we actually equip and train our lawyers with basic skills that teaches them about where to go, how to approach these issues using quasi-judicial bodies and the judiciary itself. And then also deploying things like those basic principles of administrative law that we were taught in school, judicial review, and others. So that is basically our focus on this. I had ended the paper by saying that it is my hope that this afternoon's conversation will establish that all that I have said in this paper does not make sense, and that a better perspective is introduced to the search for enhancement of practice skills in public interest lawyering. I hope that I have made sense at all in the little time that I have, and I thank you for the opportunity of having addressed you. Thank you very much.
Thank you, Mr. Erojikwe. We invite to the podium Aderemi Oguntoye, who is a member of the NBA Public Interest Litigation Committee. 7 minutes, sir.
Mr. President, the matriarch of the bar, Chief Folake Sholanke, Senior Advocate of Nigeria, learned Senior Advocates of Nigeria present, distinguished panelists, the chairman of the session, colleagues. My paper is, I have a slide that I prepared with the help of some of our colleagues in the Public Interest Litigation Committee. I'm not sure if the slide is with you, but if the slide is not with you, because I've submitted it to the organizers, I will quickly run through it in 5 to 7 minutes. So, January of this year, the president of the bar of the Nigerian Bar Association, Mr. Olumide Akpata, invited some members of the bar to a meeting and said to us that Nigeria is in a critical moment and that it is important to quickly put together a public interest litigation committee to work hard, exchange ideas, and after exchanging ideas, fertilize these ideas to come up with a position. And at the moment we take a position, that position will represent Nigerian lawyers. So when the president met with some of us, like Dr. Charles Mekunye, who is the chairman of the PILC, NBA PILC, and the chairman of the section of Spidel, and Ambaba SAN. In less than 2 weeks, we were able to come together with the position that the best way to tackle national issues through the NBA nationally is to have a public interest litigation committee. We were able to come to the conclusion that this is not going to be another non-governmental organization like SERAP, where people just jump to court on any national issue without necessarily considering the dictates of the national issue. So there were about 14 members in the committee. We have about 3 senior advocates drawn from the geopolitical zones. And we got to work. But one of the things that we did that was different is the fact that as soon as we identify a national issue, we hold a meeting. In fact, we hold several meetings. So that from the conception of the national issue up onto remedy level, the remedy we are going to be seeking from court, we conceive of what will be the outcome from the beginning. So the first matter we took up was the issue of the extension of the tenure of the former IGP. That matter is still in court, and we are determined to see it through because politicians have their way and memories are always short in the polity. So it is important to develop our jurisprudence to ensure that that matter is seen to conclusion. So that we don't have, in 2023, another president come around and suddenly have a high GP that the tenure will be over, and the only solution he would have is to ensure that the IGP's tenure is extended because the IGP is someone that he favors. In 4 months, we've been able to file about 5 matters in court. The second matter we considered and we worked on was the issue that had to do with the Cross River State magistrates. The president of the bar informed us that this particular matter is a matter that he wants us to fight to the end. The president had made efforts to negotiate, to mediate, and we realized that the chief executive of Cross River was not bulging. So we divided ourselves into groups. There are some of us who were researchers. There are some of us who had to travel all the way to Calabar. And we held several meetings with the magistrates who were not paid for about 2 years. The third matter that we dealt with, there was a policewoman in Ekiti State who was dismissed because she was an unmarried pregnant policewoman. That matter we have taken to the court and is pending adjudication. We also took the case of a fundamental human rights action against the Economic and Financial Crimes Commission for the infringement of the constitutional rights of a Nigerian bar member, one of our own, while he was carrying out his professional duties. Because the president told us that part of our mandate is to ensure that the dignity of every Nigerian lawyer is protected. So when we have issues like this, we have several calls from different parts of the country, different branches of the Nigerian Bar Association, and they inform us that there is an abuse situation. We don't just jump to court. We research and we go through the dynamics of each and every case. So that's where we are at the moment. Well, in 2 or 3 minutes, I will wrap up by saying that the strategy for broadening our intervention in public lawyering, public interest lawyering, we need to partner with Nigerian lawyers that are interested in this area. We are interested in partnering with different lawyers from different parts of the country. If this is an area that you are interested in, public interest lawyering is a sacrificial calling. It is something that you don't get immediate reward. It is something that it's an area of law that you must be ready to give everything, because the moment you are in court and you are representing the Nigerian Bar Association, and that is the reason why in the 14-member committee that we have, we just don't file actions. We see to the actions that this is something that can be defended, and we are not moved by emotions. So because we have turned down certain cases where we realize that this is not going anywhere. So we are looking for partners, but in looking for partners amongst Nigerian Bar Association lawyers all over the federation, we're not looking for people who want to add to their cases because they want to file or apply for SAN. We're looking for people who genuinely want to do this for the cause. In broadening our horizon as well, one of the reasons is the fact that we are here. Funding is a major issue of public interest litigation. And a discussion we are having at the moment with the NBA leadership is how to ensure that there is sustainability in terms of funding. I will stop there for now, and hopefully when the questions come, I can broaden this. Thank you so much.
I will immediately go to the discussants. I can see Professor Mrs. Bangboshe SAN, and I would ask for intervention immediately. Professor Spidel, public interest litigation. We just want you to address us specifically on the increase in domestic violence. We have talked about paternity fraud. I think that is a breakdown of a relationship somewhere. The consequences. Why do we have an upsurge in domestic violence? And what can public interest lawyers do in that department? Thank you, Professor.
And MBA, the matriarch of the bar, Chief Folake Solanke, SAN, the chairman. Please allow me to stand on existing protocol. While I briefly talk about what you've just said, I may have one or two comments on the presentation that we just had. On the issue of domestic violence, especially during this COVID-19 pandemic, one of the reasons why we have the high surge in this is because we're getting agitated, staying at home. People had enough time to be able to see what was going on between their spouses. People who would have been able to go out of their domain, of their houses at a particular time, and they could expend energy on other things, were now being constrained at home. One of the issues we had at that time were businesses that could not progress, and people got agitated with what was going on. In the issue of also sexual violence, many of the school children had access. These criminals had access to many of these young ones who were too. So the issue of domestic violence, be it sexual assault or be it the assault itself, got aggravated during and the Women's Forum, MBA, look.
Professor, please, it would appear that you are moving. If you could just stop by somewhere for the next few minutes and then give us your thoughts, because we are missing the audio from your end. Okay, while we sort that out, I will quickly invite Mr. Jude Ehiedu to give us his thoughts, and we are limiting you to the issue of locus standi in public interest litigation. 3 minutes.
Thank you, Mr. Chairman, and all protocol duly observed. I must commend the NBA for setting up this committee. Because this is the first time in the history of NBA where the executive will set up a public interest litigation committee to handle cases like this. In spite of the importance...
Yes, please. Sorry, I'll come back. Can I just end? I'm sorry. Can I just finish the comments, please?
Please mute Prof for now. We will get back to her.
Okay, thank you.
So, in spite of the importance of public interest litigations, and in spite of the importance of this the committee, I must say that there's some hurdle, some challenges that they may face in going forward. First and foremost, in the area of local standing, as related to fundamental human rights, I want to say that that has been settled with the enactment of fundamental right rules that have settled that So it is safe to say that anything concerning fundamental rights, yes, we can go to court to enforce a right on behalf of someone. But when it comes to public policy, constitution, abuse of power, there's still gray area. There's still gray area. Unfortunately, the apex court has departed from the usual Abraham Adesonya's finding. You know, they departed from that in the case of Ghanaian against Ghanaian Fayemi against Akilu. So also in the case of Ghanaian Fayemi and the president. So in the recent case of Center for Oil Pollution Watch against NNPC too, they've kind of liberalized the approach to issue of locals. But notwithstanding that, you must also show your interest in the subject matter. So the fact that we are lawyers, the fact that we are committees set up by the NBA to protect public interest or to fight for public interest does not entitle us just to approach court, just to run to court. We must show our interest. So that is a gray area that we must look into in going forward. And also too, there's a big problem the area of enforcement of court order and judgment. We all know more often than not the executive hardly obey the court orders and judgment. Today, just they're on strike. Before they proceeded to strike, right, they've been to court. There's a court order pronouncing the judicial autonomy. Up to today, that order the order of judgment has not been obeyed. So also the case of Dr. Lisa Bakoba against the President of the National Assembly. The court has made pronouncement in respect of that. Till today too, that order have not been obeyed. So if it has been obeyed, today I don't think there will be anything like judicial strike. That is when it comes to the declaratory judgment. But the area of enforcement of monetary award, that's another big area, you know, because we all know by virtue of section 83 to 94 of the Sheriff and Civil Process Act that provide for enforcement of a monetary judgment. Before you can enforce a judgment against a public agency, you must get Attorney General consent. And more often than not, I mean, I've not seen a situation where the AG has given consent for the enforcement of for the enforcement of fundamental rights. I mean, for the enforcement of the judgment. So that is why today the impunity of the Nigeria police has still continue because once judgment is awarded in favor of the applicants, they hardly pay, and there's no way you can enforce it.
Thank you very much, Mr. Ehiedu.
Yes, sir.
Let us now return to Professor Bangboshe, SAN, to conclude our thoughts with us.
Thank you very much, Mr. Chairman. I just want to point out that when we're talking about public interest lawyering, that the public interest litigation is just one component of it. And our lawyers should not shy away from the fact that public interest lawyering is very important for everybody, not only for those that are in litigation. And I want the PILC to note that the name PILC, have we ever considered that we put it as PILLC so that the lawyering aspect will be there? It's not all cases, and they may come across cases that will not go to court. And finally, I just want the NBA to, the way that the NBA can facilitate public interest lawyering. Mr. Ogutoye talked about funding, very important, and we can establish a trust fund where members of the bar and some of the top firms can contribute. Then there's need for more awareness. We need more awareness in this area of public interest lawyering. They're calling for more people. Then the collaboration with other fora and sections and other organizations These are very important things. And then I'm impressed by the reports that Mr. Ogutoye has given. If there could be quarterly or biannual reports, this will spur and this will encourage many people. And I think based on that, I think my 3 minutes will be up, and I really want to commend the PILC for the work they're doing. So if you add PILLC, so that it won't just be litigation, so that people who are not in litigation will not just feel that it's for people in litigation. Thank you very much.
Thank you very much, Professor, for your thoughts. I saw Shinoyo Biagu, SAN. Okay, he's gone offline. He's online now. Can we get him on? Can we get him on? Leonard Sil, can you hear me?
Yes, I can hear you. Good evening.
Thank you very much. Leonard Silk, for more than 20 years, I've known you to be in the NGO stuff, dealing with public interest litigation all over Nigeria. In 3 minutes, what would you tell a lawyer seeking to follow your path? What virtues, what qualities, and what should he expect going forward? Thank you.
Thank you very much. I want to convey my deep apologies to the president of Spidel and organizing members of this conference for an inability to be here physically. But thank God for visual access. Public interest lawyering is an interest in law, just like Professor Bango said. It's not just about litigation; it's about advocacy. And I'm glad that a lot of young lawyers are showing interest in public interest litigation, in public interest casework, which starts from policy, driving the policy changes to law reform, and then using the courts as instruments for social change. Going to your question, what will advise young lawyers involved who want to be committed to public interest litigation? Well, first, I must warn that it's like squeezing water from a stone, because most times you embrace public interest litigation on areas that are very novel. I mean, when we started talking about socioeconomic rights, we litigated a case in which we got the Federal High Court to declare that Section 18 of the Constitution, which is Chapter 2, provides for right to basic education. That right endures as a Chapter 4 right, because the National Assembly has made Universal Basic Education Act, and once the National Assembly makes an act on a matter under Chapter 2, it becomes a fundamental right and becomes justiciable. So that is a novel pronouncement, and therefore every public interest litigation lawyer or advocate must be prepared to think outside the box, must be prepared to go beyond the usual rhetorics of adversary and president on the issue of local standard. And of course, I agree completely with Mr. Hedu that the court has moved progressively away from the narrow confines of Ibrahim Adesanya and the president. But we still need to do more in this country. One good thing is that the fundamental rights enforcement rules has opened the door that people can litigate in the interest of people who suffer violations, even when the victims are not the plaintiff. So the second challenge that the lawyer may be faced is the issue of the lack of judicial activism in this country. A lot of judges find it very difficult to understand the concept of public interest litigation. I think Nigerian Bar Association needs to do more to reach out to judicial officers. I mean, we find cases where very recently the Federal High Court judges are beginning to award punitive costs to non-governmental organizations who take up public interest litigation. I mean, we have cases where SERAP was awarded a cost against SERAP for 100,000 naira because it's a public interest case. Now, the issue of cost is also important because filing fees is exorbitant now for public interest cases. In other words, a public interest litigation, a public interest advocate must be able to have other things, have a strong law practice that will sustain his practice, because public interest law is something that is done in the interest of the public. Therefore, it is a public defender scheme. But I will encourage a lot of young lawyers to begin to look for openings in areas like freedom of information. Now, Freedom of Information Act was enacted in 2011. It provides us with it provides lawyers with a good opportunity to demand accountability for public officers. And Section 20 has given that broad mandate. So that's a good starting point, because the statute itself has opened the door for local standard in the area of freedom of information. So on that note, I want to thank you again for giving me the opportunity to express my views. And
thank you very much, Leonard Silk. We very much appreciate you. Now, the Leonard Silk just said we should look for a way to get young lawyers on board. We have here with us the representative of the Young Lawyers Forum, Toby Adebowale, is represented here. How can we get the interest of young lawyers tied up in public interest litigation issues?
Thank you very much, sir. The president of the Nigerian Bar Association, the matriarch of the bar, Chief Mrs. Folake Sholanke, and Learned Silks here present, all protocols duly observed. I will try in 3 minutes to highlight some of the issues that we have identified. All right, thank you very much, sir. And first and foremost, I need to apologize for the absence of Mr. Toby Adebowale. He could not be here. He tried very much to be here, and that's why he cannot as well join virtually. So straight to the issues. First and foremost, I think that public interest lawyering is something that young lawyers need to be granted permission to do. And what do I mean by this? It is common that when these kind of issues come up, and young lawyers are sometimes the first responders, by the time it becomes a national issue, you see the silks coming, taking up some of these cases. And there's absolutely nothing wrong with that. There's a lot of experience, there's a lot of influence that comes to bear in some of these cases. But wouldn't it be nice if you can find a young lawyer given the full support of the bar to prosecute some of these cases? When we see an example in one of our members or in one of our colleagues, it gives other young lawyers the motivation to try these things out as well. So I think the first thing is we must give permission to young lawyers to begin to get involved in this. It doesn't have to be senior lawyers all the time. A young lawyer can do as well if given the right opportunities and the mentorship that is needed to excel in this field. The second thing I want to raise is the issue of protection. Young lawyers need to be protected. Many times, public interest litigation, public interest lawyering is a David and Goliath task. And for a young lawyer, it's no longer David and Goliath. At least those are two human beings. It's more of an ant and a mammoth. The influence that governmental organizations and some of these other institutions that you go against, the influence they are far-reaching for a young lawyer. So if a young lawyer is not protected by the senior advocates, by the Bar Association, and by so many institutions that surround litigation and lawyering in Nigeria, it is likely that a young lawyer will be discouraged from participating in such a task. I know Mr. Edun is going to speak on some of the challenges that comes and some of the threats that comes with being in public interest lawyering in general. And the final thing I want to say is that young lawyers must be given an incentive, and I'll call this profit. And when I say profit, I don't talk about money alone. I'm talking about giving recognition. Something as simple as a tweet on the Nigerian Bar Association Twitter handle can go a long way to motivate young lawyers to want to participate. So in summary, I think I just want to talk about 3 main things. The first one is permission. Give young lawyers the permission to do this by giving the necessary support. The second one is protection. Protect their interests, protect them from the mammoth-sized organizations and institutions that they are going against. And the third one is incentive or profit. Motivate them with recognition. Thank you very much, sir.
Thank you. Let's give him a round of applause. Better than that. Now we have some lawyers who have worked in this area of practice for a long time, producing results. Maybe recently we heard of the judgment delivered by the Court of Appeal, where they held that the state had nothing to do with roadworthiness of vehicles. We also heard about the case that went up to the Court of Appeal on the issue of the Chief Judge of Cross River State. Common denominator, Kunle Edun Esquire, National Publicity Secretary of the NBA. You have been doing it for some time. Tell us how you got here. What is the propelling force?
Thank you very much, distinguished session chairman. I further recognize the presence of the NBA president, Olumide Akpata, and our Maison, distinguished learned 6 year present, and distinguished colleagues. Thanks for waiting so far. Public interest litigation, actually, some persons consider us to be rebels. You must actually be a rebel, a warrior, to succeed in public interest lawyering. And you must be able to challenge the status quo. If you're not ready, then sorry, you still have a long way to go. Like the session chairman said, some of us, we have taken it as our destiny that we are going to challenge the status quo. Now, it's not about one or two, three cases. It's several cases, several judgments. I've had cause to also lost in some of the cases, not because the cases, the points that were canvassed were not very valid, but because the institutions were fighting against me. And all of us know how it is when you dare the institutions, the high powers, the politicians, and it's a very big risk. So some of us are very well tagged rebels. Good enough. And it was on the basis of that I now said, enough is enough. How can I, in the city where I stay, in Warri, I see you stopping vehicles on the roads. I see you asking them mounting roadblocks on the road, and in the course of doing that, you collect monies from them. You don't really check. You extort monies from them. And I said, very well, no problem. Try it with me one day. I am a lawyer. I'm a superhuman being a lawyer. And I see it that every lawyer is a born human rights activist. Every lawyer is a public interest litigation person. So it's not a matter of Femi Falana, myself, or yourself. No, it's all of us. The NBA will do its part, but we must, as lawyers, also contribute our part. Now, going back to the VIO issue, they stopped me. I said, okay, no problem. They said I should park. I said, no problem. Where are my papers? I said, what papers are you asking? Are you not a VIO personnel? Why are you asking for my papers? They said, okay, if you don't answer, if you don't give your paper, then you go stay there. I said, no problem, I will stay. Of course, I wasn't going for a very important mission as such. So, crowd gathered. Vehicles were piling up. I said, good. Of course, you trust us. I said, okay. Said, Oga lawyer, you won't believe it. Even some Nigerians were even advising me. Oga lawyer, give them money. Oga lawyer, give them money. Of course, I ignored them because they are ignorant of their right. And I said, today, I'm going to handle this issue. So, of course, that was what led to the court action. Because I said, for detaining me for more than 10 minutes, right at that spot, you have violated my right to freedom of movement. So we went to court. Of course, in the course of doing that, I had to do some research on the law, the road traffic law and regulation in Delta State. And I discovered that this was actually not a fact. I had the roadworthiness certificate, but I did not give them any document. But I don't notice that, for crying out loud, this guy did not even have that power to be collecting monies from me to pay for roadworthiness certificate. I said, oh, interesting. So we filed the case in High Court Ughelli. Of course, we won the case. But the Delta State government still dared to go to the Court of Appeal. I was expecting that as a responsible government, when a citizen of Nigeria goes to court to highlight certain issues in the public interest, you should be able to oh, what have we done wrong? What have we not done wrong? So I would say that they would have looked at that judgment and said, okay, let's do the right thing. But they still went to the Court of Appeal. Of course, it took about 4 or 5 years. We did it. Very expensive. No problem in the public interest. At the end of the day, we got judgment. And that judgment went around the whole country and it states very well that VIO officials, you have no right to even mount any roadblock on the road, number one. VIO officials, number two, you have no right to demand for vehicle particulars, roadworthiness certificate, even any particulars from private vehicles. Number three, VIO officials, if you want to do your work, it is at the stage when the person is applying for renewal of his certificate, vehicle papers. That is where you do it, not on the road. And even the judge, the trial court in this case was even saying that if I had actually asked for 5 million damage, the court would have awarded it. That's the trial court judgment. Now, what are we saying? Public litigation, we lawyers must continue to use public interest litigation as a means of social engineering. It is very, very important because it is when we have a situation of rule of law, that is where the legal profession prospers. I'm telling you, because in a state of misrule of law, we, particularly the yoga lawyers, we can't make it. You go to the police station, you go to various places, it's all impunity. And we cannot continue to allow it to be like that. And it is interesting that I thank my president for setting up the Public Interest Education Committee, of which I'm a member. We have done some. We have a lot to do. And I can assure all of us here that at the end of administration, very well, the Public Education certainly will be a name to be reckoned with. Thank you very much.
Thank you. Mr. President, sir, they have said so many things about the Public Litigation Committee. Thank you very much. That's a very, very big boost for the dreams and aspirations of Spidel. But one issue keeps coming up, which we would want you to address for us, but I just want to sensitize you on this. Public interest litigation is expensive. You could go from here to Kano to Kaduna. Is there any form of support for the committee to enable them operate effectively? Probably that will be where we will part on this session. We will take the last two speakers because something is about to go on demonstration. Sorosoke should be the foundation of Spidel activities. You see it, you voice it out, you speak it. Do we keep quiet? No, we must speak up. I would invite Bernard Oniga to tell us something about a new app.
Mr. President, Chairman of Spidel, permit me to stand on existing protocol due to time constraint. Let me also recognize Chief Michael Zekeme, though he's unavoidably absent. He is a chairman of the National Human Rights Committee, and I am undertaking this task on behalf of the committee. Mr. President did set up the Human Rights Committee and tasked us with a mandate to look into human rights abuses across the country. We have started our work in line with that mandate, and I am here to report to you that we are laying a robust foundation because it is not every administration of the MBA that sets up that committee. And I would dare to say it has not been as effective as it ought to be. So you have not heard much from us, but you will hear so much from us right from this moment because we plan and we intend to do so much as a committee. Let me, by way of contribution, add that public interest is a first point of duty for every lawyer. It is like the military. While growing up, I was amazed that, oh, you had cooks in the military, you had doctors in the military. I thought it was all about war. But whenever the sound of war or the bell of war is rung, that everybody, the Reverend Father picks up his gun, the doctor picks up his gun, and the lawyer also in the military picks up his gun because he is trained in the art of warfare, and warfare is the primary responsibility of every military official. So I would want to say, by way of contribution, that public interest is the first line of duty for every lawyer, irrespective of practice area. It should be inculcated. And let me also say this to the chairman of the board of the continuing legal education. We should adopt a radical approach when it comes to education in respect to public interest, so that for those of you who make money from commercial practice too, when that bell is rung, you will be able to put on your military regalia and go to war with us. You know, it's very important. Our committee worked closely with a company known as Quanterium. It's a digital marketing company. Yes, to produce an app called Sorosoke. We are all aware of the violations and reports on time. It will help and assist the NBA with respect to data, in respect to breaches by police officers, as the case would be. This is how it looks like. This is the interface of the app. Also, the Human Rights Committee is doing a whole lot in sensitizing Nigerians. We have our Facebook, Twitter pages, and we also have phone numbers in which Nigerians can reach us directly to report human rights breaches and complaints. Like I said to you, we are ready, we are up and running, and by the grace of God, you will hear so much from the National Human Rights Committee in no distant time. Due to time constraint again, I would invite the MD CEO of Quanterium for a brief presentation on how the app works, and then I think we'll take questions and based on that.
You are taking over my functions.
Oh.
Mrs. Michelle Omogun Anekwe, MD Quanterium. 3 minutes.
Good evening, everyone. I am Michelle Omogun Anekwe. I would like to stand on the already existing protocols. Sorry, please permit me. I'm not a lawyer, so I wouldn't know what to say. But I am here to present to you the Sorosoke app, and I would just like to give a 1-minute background on how this whole idea started. So there is this saying that when you find something wrong or you're not comfortable with something, then you work towards solving that particular problem. And human rights violation in Nigeria is something that I think everybody has faced, either from a government official or even from fellow citizens. We all complain that our leadership are actually not so good, we'll say, but somebody else still said that our leadership is simply a reflection of our citizenship. Meaning, if they bring somebody up to the same position, the person will act the same way. So without boring you with so many of these talks, I wanted a situation whereby people can get easy access to justice. So this is my own part as a citizen of Nigeria trying to find a solution to a particular problem that I personally have faced over the years, which is human rights violation. And it has gotten so bad in Nigeria that everybody feels, or most people feel, they can get away with these violations because the victims may not have appropriate channels to, I would say, to help them get justice. And some people, due to probably social status, would suppress these victims and then they end up dying in silence. So Sorosoke is just like they said, speak up. So we wanted a situation whereby people can, even if they want anonymously, report incidences with evidence that can be verified by the NBA, and they are helped to get justice.
So when will your app be up and running?
Okay, yeah, the app is already running, but for the purpose, please the next slide. But for the purpose of this presentation, the preview is up online, and I would share the link shortly so that we all can register and then get notified. But by the end of this week, the whole Nigeria should be able to start submitting their human rights cases, and then we'll see. So please, let's just go straight to the interface. So this is how it looks, and I forgot to mention, it's also a surveillance tool. So it's not just for people to report system, it's for the public to also see a real-time dashboard of cases that are being reported and how they are being handled. Sorry, just back to the slide, please.
You have 2 more minutes.
All right, so I'm just going to run through the slides. So this is how the user gets to report the application. Next, please. So they are given different categories, group categories of cases they wish to report. So we have gender rights, child rights, socio-economic, civil and political rights. So they get to select whatever they want. And next, please. Next. So you can just keep going. This is just taking you through a short preview. But at the end of the slide, you get to see the link where people right here can actually register for the newsletter, and then they will be noted, they will be informed about the updates on the app. So due to time constraints, I may not be able to talk so much, but I hope with this little presentation I've made, I've been able to bring everyone to note on what the Sorosoke app does. So right now, if you go to the domain that is displayed on the system, you should be able to register for the newsletter, and then later this week, you get notifications on the live preview of the app. Thank you.
Is there a possibility that we are going to get to training on this?
Okay, so the whole idea of partnering with NBA on this is that even if people have submitted their cases, lawyers have to be on the other end to respond to them. So there's an admin portal that will be used by the lawyer, and they will be trained on this portal to respond to cases that people are sending.
Thank you very much.
Thank
We
you.
appreciate your coming. Now, I had previously engaged the president of the NBA on the activities of the litigation committee, and that is where we will wrap this up. Mr. President, sir, what support are we going to get for that committee, and how effectively can we handle issues relating to public interest litigation being handled by that committee?
Okay, thank you. Thank you, moderator. I want to say firstly that the NBA works effectively through committees. And as you are aware, can you hear me? Yeah, I think it's back on. As you are aware, one decision we took as this administration at the NBA was to re-energize, to reactivate all our committees. And I want to charge members of the association to ensure that this is sustained. The only way our association can be effective is if our committees are up and running. And for committees to be up and running, there must be a plan to finance the activities of the committees. So this brings me in a roundabout way to your question regarding the Public Interest Litigation Committee. And the committee has already started. The members have been up and doing, well-meaning, funding their activities. And we are working on a financing model now on how that can be established on a sustained basis. Budgeting, what kind of subventions can they get from the association? Can we do fundraising drives? Somebody even mentioned there's something we're looking into, a fund, where there are law firms that want to contribute to the activities. I know many have reached out to me, so it's to put the model in place. So that's work in progress. If it is not done, the work will stop. If it is not done, the work will not be sustainable. So we're thinking hard in this direction. Now, this one working? You will have to, can I just go back 1 second? I hope I've answered your question on funding. It is work in progress. I'm talking regularly with Dr. McQueen, the chairman, it was very important to us that Public Interest Litigation Committee be set up. And there's this chairman of Spidel is an ex-official member of that committee because of the natural link between the two bodies. But I want to go back to the Sorosoke app. And I want to thank Michelle for all the work you've been doing, working closely with the NBA, with the Human Rights Committee. Again, staying true to our mandate to promote the rule of law, to protect the rights of the individuals, we thought it was a fantastic idea to collaborate with Quantarium, Michelle's organization, to put this app in place so that we use technology, we leverage on technology to bridge the gap, to make it possible for those who may not be able to walk up to a police station, who may not be able to come and report incidents of human rights abuse or rights abuses, to use technology and shorten the process to make sure that their issues can be put on the front burner, with the NBA helping to facilitate this. And you know, we signed a memorandum of partnership with the National Human Rights Commission. So we intend to be working closely with the Human Rights Commission. We have 125 branches. The Human Rights Commission has 36 offices around the country. We want to make sure that actually we can help people bring their issues to the fore. And technology definitely will put us in good stead. But I will crave your indulgence. I don't believe in coincidences. This afternoon, I visited with the matriarch of the bar, our First Lady Silk, Mama Chief Mrs. Folake Sholanke, who is here with us, and for which her presence here, I'm indeed very grateful to her that she has taken time to stay with us till the close of this last session. And we had a long conversation, but you know what? The uncanny thing is that amongst the things our First Lady Silk said amongst the things she talked about was that lawyers should sorrow soke. That was, so she said that in her living room this afternoon. At that point in time, I totally forgot that we will be launching the Sorosoke platform this evening. And so as I was sitting there, I was mulling over it. I said, that was not a coincidence. You know, things work in a certain way. But Mama said, we should be able to speak up. It is it's par for course. It comes with the territory as being lawyers to Sorosoke. And what here is launching today, the Sorosoke app, which in collaboration with Quantarium. So I think it will be fitting for us to bring, even if symbolic, because Mr. Chairman, you had asked what the status is. So they're in testing phase. In another week or so, we should be able to go live and people can use the app. But let us use the opportunity of this conference, Spidel conference today, to at least show the world that we are moving in this direction. And we have our First Lady Silk here, the matriarch of the bar. I think it should go with her blessings. So if you would kindly allow me, we had some, so I would like, Victor, if we can take a microphone to Mama. And Mama also has words that she would like to share with us, and we can never learn enough from this fountain of wisdom. So let Mama launch the app for us and then also speak to us.
Thank you so much for this opportunity.
Let Mama speak first, though Mama has a few things to say. Look. Yes.
The President, I'm most grateful to you for this opportunity to respond to what you have said. And I would like to thank you very much for having visited me today. I have been visited by many people from civilian to military, and this is the very first time that the reigning president of the NBA will visit me. Please give him an applause. There's biblical support for Esorosoke. It's in Isaiah 35, verse 7 and 8. It's right there. Speak up for the needy. Speak up for the destitute. So I will send the correct citation to the president, but I think I got it right. And it's my joy to have been asked. I didn't even know that Sorosoke platform has been established. That's a marvelous development from the horrors of End SARS. Something good. Something good has come out of it. And when I'm at the meetings of senior advocates of Nigeria, when I conduct the meetings, I am always asking them that every lawyer has a voice. Yes, I'll do whatever you tell me to do. I'm under instructions. Emma Wo. Careful. I have to have one.
Who do we have, please?
Yes, well done. You did a good job. It's okay. But it's platform, isn't it? The name is Sorosoke Platform.
So we're delighted to have First Lady Silk launching the app for the launching the MBA Quantarium Sorosoke app. So I think once the First Lady Silk counts to 3, we will all shout Sorosoke.
I say 1, 2, 3. All right. Anyway, before I say 1, 2, 3, wonderful event. This is one of the highlights of this marvelous conference. Congratulations to you for what you're doing and to all your supporters here. It is with joy and with prayer that I launch this platform, Sorosoke platform, for the whole of Nigeria. And it gives us a platform to speak up as Sorosoke. May God bless the platform. Amen.
1, 2, 3. Sorosoke.
Another one.
Sorosoke.
Once more time.
Sorosoke.
Thank you very much. Then I'll give my small speech. I was going to say something anyway. Okay, let me bring up my... Please wait, please wait, please wait. I want to Sorosoke. Please wait. I have to Sorosoke.
Please wait, oh. Mama has to say something.
Yes. You know, I'm so addicted to the law. I am addicted to the law. I love the law. So it breaks my heart when the law is broken. When the law is broken.
Please, can we just be quiet? The Learned Silk is speaking.
Thank you very much. I'll go on from what you have just said. We have certain maladies in our profession. And that's serious. When I say I purposely chose the word malady, serious illness or disease. One, we do not listen when people are talking. Somebody is giving a lecture and people at the back and elsewhere are talking. It's an act of discourtesy and it's not good because we are professionals. I tell everybody, a good lawyer is a good speaker and a good listener. You must listen to what your opponent is saying before you can respond adequately. So please, let us try and work on this. I urge the branches to work on it. Lawyers must listen when people are giving lectures or talking. Even today, with everything that was going on the stage, at the back, there was a lot of noise. People were not listening. And these are very important issues being discussed. That's one point about listening. Another one, punctuality. We have Nigerians, many Nigerians have disrespect for time. Time is one of the greatest assets we have. Once lost, you never gain it. We started this event at 5 minutes to 10 yesterday. It ought to have started at 9. At 9 o'clock, hardly was anybody here, except some people. So please, punctuality, punctuality, punctuality. And then, appearance. I get complaints from judges, and I have to speak very delicately to my own fair gender. We wear wig upon wig and mountains of wig. And the judges, they complain to me. You don't go to court to irritate a judge. You want to be on the good side of a judge. Not that it's going to be partial, but you want to be on the good side of a judge. If you now go with the wrong apparel, the wrong hairstyle, there must be no hair in front of your head. This place must be free of hair. And there's no need to have these volumes of hair on top of the wig. So everything in moderation. I wear a wig, but then I don't wear anything that's going to be outrageous. I don't see what horsetail is doing at the back. And then as a wig. So please, when you go to court, it's not an opera house. Serious theater of work law. Make sure, my learned friend, that you do the proper thing. Something, reduce the volume of the wigs, reduce the length of the wig. Look at our Secretary General, General Secretary. Moderation, moderation, moderation. Then the next thing I want to talk about, that's the courtesy. Courtesy. Courtesy, respect, is one of the pillars of the society, of the profession. And it's well located in Nigeria because Nigerians pay a lot, at least those who are brought up well, they pay a lot of premium on being respectful to the elderly. In the profession, seniority rules. Because the seniors have saved the profession for the juniors. The juniors must now save the profession for those who are coming after them. When you go to court, if your senior arrives, you get up. Even within the senior advocate, if Professor Kasumo or Professor Nwabweze would come to court, I'm sitting down, I get up for them. They're my seniors. But now, both in the inner bar and outer bar, people see seniors and they're sitting down. Seniors, please, take them on. If the junior is sitting down, you're standing, take them on. It's unprofessional. It's against our tradition. Courtesy, courtesy. By making sure you respect your elders. Let's see if there's any other thing. I think I've covered most of the issues. So I have Sorosoke, Moti Sorosoke. Please continue. Oh, when the president visited me today, I told him that I encourage chairmen to deal with these matters at their meetings, and that they can, for critical issues, they can take decisions, issue a statement on their own resolution. That doesn't stop the national voice. All of us must speak up. All of us must speak up. We know we have the national voice, and thank goodness that national voice is vocal now, vigorous, resonant. Thank God. Thank you.
Distinguished ladies and gentlemen, on behalf of the Council of Session, on behalf of Spidel, I stand before you to appreciate every one of us who have been here since the beginning of this conference on Sunday evening till this moment. I cannot but specially appreciate our mama, our matriarch, the first senior advocate of Nigeria, who happens to be a gentleman in skirts in Nigeria. Chief Mrs. Folake Sholanke, of Nigeria, for being with us from yesterday till this moment. There is nothing and loyalty to your association as she has professed to all of us. And she has shown us that in this legal profession, we must all abide by the ethics and ensure we sustain the nobility of the profession. Through our matriarch, I appreciate every one of us who have graced this occasion from yesterday to this moment, and I especially appreciate all conferees who have come from all parts of the country to be part of the conference and made this conference a most successful one. The CPC, the council members, the LOC, especially I must also appreciate the rapporteurs for the wonderful job they have done, and all those who took part in making this event a success. But I must not end this without specially congratulating and appreciating our very hardworking president, Mr. Olumide Akpata, who gave the Spidel the opportunity to put this wonderful event together. Thank you all for coming. Thank you all for being part of the program, and thank you all for making it a success. God bless you all, and I wish you all a journey mercy back to your various destinations. Thank you.
Right. So, ladies and gentlemen, well, colleagues, learned senior advocates here present, our Honorable the Attorney General of Oyo State, who still be, please a round of applause for the Attorney General. Professor Oyelowo Oyewo, Senior Advocate of Nigeria, thank you, sir. Thank you for your commitment to the association. We are so grateful to you. And I must say quickly, thanking the Chairman of Spidel, Professor Elder Ananaba SAN, Chairman of the Planning Committee, Monday Onyekachi Ubani, MOU, the members of council, thank you very much. The hardworking young people, Paul Daudu, Victor Wakasi, I see all of you here. Emeka Nwadioke, please, in case I have not mentioned your name, I want to thank everybody for the hard work, for making this come to pass. It was almost looking like our conference was jinxed, but somehow, by the grace of God and with the help of our Attorney General and his government and our members, it has come to pass. So, it gives me great pleasure to declare this conference closed, but asking us all to look forward to the next edition of the Spidel Conference 2022 by the Dio Volente. Thank you very much.
Thank you, sir. Thank you, sir. Thank you, sir. Thank you, sir. Our president, thank you very much. Now, please listen to this announcement. There is going to be a party. There's going to be a party at the bar center for all our conferees. For all our, yes, at the bar center, yes, we have resolved that. Then there is a select dinner for few bar leaders at the governor's lodge. So please, those who are selected, please, you make sure that you are around. We are leaving now. We are leaving now. If your name is not on the list, don't bother coming. But be at the bar center. It's going to be party till daybreak. Thank you, and God bless you. See you 2023. Oh no, 2022. 2022. Thank you very much. Please, there's somebody looking for an earpiece. An earpiece it was misplaced today. Yeah, misplaced today, please. If you have seen it, please try and return it to the organizers. Yes. Why, yes. Riomo, yeah, please, earpiece. If you please, by mistake you picked it, please come to us here at the technical side and return it, please, and God will bless you. Thank you very much.